This court disagrees. Judge strongly rejects absurd effort by Fani Willis to avoid subpoenas for documents and testimony about Trump RICO prosecution. The chickens are finally coming home to roost. She's been trying to ignore the subpoenas, which is crazy, which is rich, from a district attorney who's charged with prosecuting and following the law. She is totally disregarding the law. She got subpoenaed to be questioned to find out what's going on with her, and that RICO prosecution that they try to put on Trump. Was she working with the White House and they wanted to come in and ask questions, and she refusing to answer those questions? What are you hiding? Because if you have nothing to hide, why are you afraid to go and talk to the judge? So we're gonna talk about it. But before we get started, go ahead and hit that like button. Share this out so we can get this information out there. Subscribe if you're not already a subscriber, and hit that alarm bell so you know when I'm putting out new stuff. Also, check out my link tree in the description. It has a link to my Patreon. That's where I talk about things that I can't talk about here. There's also a link to my Instagram and my X account, so follow me there as well. All right, so let's get into this news. Now, this comes from Law and Crime by way of MSN. And they report that a court in Georgia shot down a request by Fulton County District Attorney Fani Willis to quash subpoenas issued by state legislatures intent on quizzing the prosecutor about her and her office's efforts to investigate and prosecute President Donald Trump. Again, if everything is on the up and up, if you got nothing to hide, you should have no problem in going in front of these people and explaining to them your rationale behind all of this, unless there's some sinister stuff going on that you don't want to tell these people, right? Peach State Senator Bill Cowsert, a Republican who represents the college town of Athens, is the chair of the Senate Special Committee on Investigations. The committee has been looking into Willis for years. Since the summer of 2024, Cowsert has been intent on getting Willis to talk under oath about her long, frustrated Trump crusade. Willis has resisted those efforts at every turn. Now, a court has rejected the prosecutor's latest argument by finding it would set an, quote, absurd, what the judge says, absurd precedent for investigations conducted by state legislatures going forward. And in a twifold blow, the judge cast doubt on efforts by Willis to limit the scope of the subpoenas. The focus of the committee's investigation is how Willis spent public funds on her failed racketeering and election interference investigation into the 45th and 47th president, and whether any funds earmarked for other purposes were improperly diverted. Money trail. A subpoena was issued by the Georgia State Senate in August 2024, but appeared superfluous at first. The prosecutor was slated to appear and speak under oath at a public hearing held by the committee that September, but ultimately she was a no-show. How can you get away with that? If it was a regular citizen, more than likely they would have been arrested behind that. Around the same time, Cowsert moved to enforce years-old subpoenas against Willis for documents and testimony, as well as the latest subpoena. In turn, Willis and her office filed a permanent injunction to stop the subpoenas from being enforced. In early December 2024, attorneys for the parties argued the general issue in the case was as for and against the possibility of Willis being held in contempt. On December 23rd, 2024, the Fulton County District Court judge overseeing the matter then ruled in committee's favor on the basic question of the subpoena power, denying the district attorney's petition for declaratory judgment and injunctive relief. In January, the embattled district attorney filed a new motion relying on a wholly separate argument. Willis argued the 2024 subpoenas were moot and should be quashed or dismissed entirely because the November 2024 general election necessarily resulted in a brand new General Assembly being sworn in. The state senators, for their part, quickly made sure to reauthorize COSERT's committee, but Willis essayed the details of how the reauthorization occurred precluded the subpoenas from having any real staying power because technically the present committee is a different committee than the one that issued the original subpoenas. In a 2-page order, Fulton County Superior Court Judge Shakura L. Ingram rejected that argument out of hand, noting, quote, "This court disagrees." The judge said she was sympathetic to Willis's arguments that the original subpoena were issued near the end of the last legislative term, and that compliance is perhaps better achieved if subpoenas are issued by legislatures early on. Still, the judge cautioned, quote, "There are myriad ways to tie these disputes up in court. If every time a subpoena is issued by a special committee, a recipient can simply litigate its validity and enforcement until the General Assembly reconstitutes, and then they have to start over. This would be an absurd result indeed," the judge opined. I definitely agree. That's a way out of it. Every time they have a new assembly, there's a new assembly. This ain't the same assembly that that issued this subpoena, so y'all gonna have to do a whole new subpoena, and then they just keep doing that, and then it just basically kicking the can down the road. And the judge said that's absurd. Quote, "Not least because this would mean that if the need for a subpoena did not arise well towards the beginning of a term, the General Assembly would be forced to defer issuing said subpoena until the beginning of the next term in order to maximize their window of opportunity to enforce it. This could and would result in lost evidence, fading memories, and general inefficiencies." In the end, however, the court was not persuaded by any of the timeline considerations offered by the district attorney. Quote, "Moreover, suppose the production of documents were ongoing during the transition from one term to the other. Would everyone simply have to start over?" The court's order goes on. "This court cannot in good conscience facilitate such a result. As such, petitioner's motion is denied." Wow. Notably, while entertaining the concerns raised by Willis, the court said the district attorney was also wrong on law about subpoenas. They said, quote, "This court agrees with the GOP that the authority cited does not stand for the proposition that the original subpoenas must be declared void because the General Assembly and Special Committee had been reconstituted post-election." The order goes on. In another 2-page order, Ingram warned Willis that her efforts to evade certain elucidated requests in subpoenas are lacking. Quote, "Petitioner timely filed her elaborate objections, however, they are still deficient," the court observed. Willis claims the attorney-client privilege to 3 requests lodged by the state senators. The judge suggests those claims are off base. Yeah, what client? What client? What client attorney privilege? Quote, "Here, who is the attorney? Who is the client?" That's what I was just asking. What are you talking about? You are a prosecutor. You were prosecuting Trump. So what client attorney privilege is there as a prosecutor? You are prosecuting Trump. Like, I don't understand. Wow. Moreover, the communication must have made for the purpose of getting or giving legal advice. How does that apply here? There are questions that petitioner needs to answer, or else abandon her objection to these requests on the basis of attorney-client privilege. So who is the client? Is the client Biden? Is the client Biden's administration? Like, what is she talking about here? I'm telling you, she's digging herself a worse hole here. Willis also claimed the work product privilege, a form of privilege closely related to attorney-client privilege based on work done specifically in regards to litigation or a trial in response to those same 3 requests. Again, the judge suggests this privilege does not apply unless it does apply. And if it does apply, who is the client? Is the client Biden administration? Is it Kamala Harris? Who is the client? The judge prods by noting the questions have to do with Willis's hiring of and personal relationship with former special prosecutor Nathan Wade. Finally, Ingram strongly suggests Willis is improperly claiming the law enforcement privilege to one request and all but counsels the district attorney to abandon the current exemption in favor of, quote, another law enforcement privilege and or law enforcement material assertion. Wow. Very, very interesting. She's gonna sooner or later gonna have to testify in front of these Republicans, and they are going to give it to her. She's either I can't wait for this to happen. I can't wait to see her excuses when the state Republicans of Georgia get a hold of her. But y'all let me know what y'all think about this. Leave your comments down below. Like, share, subscribe, and check out jjthepsychotherapist.com for the latest in news. Until next time, peace.